Good day, everyone. This is Richard Fink, a lawyer who specializes in workers' compensation. Today is the Legal Side podcast for injured workers. Paul?
Hello, everyone. My name is Paul Taylor. I'm a licensed paralegal by the Law Society of Ontario with specialization in workers' compensation law and human rights law. If you want to reach out to either of us or be part of our podcast, you can contact us through the links below. Back to you, Richard.
Today, our guest is Josh Kirschenblatt, a lawyer who practices law at my law firm, Fink and Bornstein, who's going to be talking about psychiatric and chronic pain issues at the WSIB. Not the staff, but the injured workers. Josh, take it away.
All right, thanks, Richard and Paul, and I'm really happy to be here. Um, so my issue, which is something that I've been noticing over the past 5 years that I've been practicing, has been that the WSIB refuses to give entitlement to chronic pain disability at the same time as psychotraumatic disability. And I can't really understand why. Um, Most of our clients, if they have one, they have the other. The psychologist or psychiatrist often diagnoses a worker with, for example, major depressive disorder and also somatic symptom disorder, which is chronic pain disability. And I did a little bit of research looking into why you can't have both, and I'm not sure it really makes a lot of sense. So I wanted to get some opinions from Richard and Paul and see what they think and see what's really going on. So
Oh, you don't want to know what I think.
I mean,
Kidding,
I
I'm
think the
kidding.
world does. So
I think to be quite honest, I've noticed in whenever I deal with chronic pain, and the NEL, is that what you're talking about? Is the NEL entitlement or the ongoing entitlement?
so both. But as I did a little bit of digging, I noticed that the NEL, the rules for chronic pain and the rules for psych are different. So that is a big deal. And I'll get into that a little bit later. But yeah, if you want to give your thoughts for a second, that'd be great.
We're losing Paul. He's having internet problems. So let me ask you the following question, Josh, which is when they come to do the NEL, don't they use the same schedule, minor, moderate, major, with the
So they
same
do use the
concern?
same schedule. The interesting thing that I found, which is actually in a couple of tribunal decisions, WSIAT decisions, is that if you have psych and organic, you can stack your NELs, right? So you can get, let's say you have an arm injury and you have a 10% um, permanent impairment. You can get a 10% NEL for your arm. Plus, later you can get, let's say you have a 20% psychological impairment. You can get the 20% plus the 10, which, ends up being around 28% based on their calculations. However, if you have CPD, they rescind the organic and they give you the CPD only. So if you have a 10% organic NEL, then you get CPD. They take away that 10% and you get whatever you get in CPD. So it's to me it doesn't make any sense. They're saying either you have psych and physical or you have CPD, but I don't see why you couldn't have CPD and organic impairments.
Because aren't they two separate things?
I mean, the thing is, the research that I've done is that they are two separate things, but you can make the argument that the CPD and the organic are also two separate things. There's research that says, okay, so let's say you have an arm injury, and you have chronic pain in your arm. It can move to other parts of the body. The issue is not that you have an arm injury. The issue is that you have a disorder. You have chronic pain disorder, and that can move to all parts of the body. It's a mental thing. It's not, it's related to a physical injury, but it's also a disorder, just like I think any other disorder. Like, for example, you don't have major depressive disorder for your arm. You have major depressive disorder as a whole person.
Yeah, and I mean, and I, how many times, Richard, have I brought up Nova Scotia v. Martin about the issue and the stigma in dealing with pain and chronic pain? And um, and I'll quote it again now just for everybody's in case they haven't heard it. I laugh because I do say it a lot because it's so important to understand what frustrates me is stigma And I think that's part of the issue is where people will go, Joss, I think there's nothing wrong with you. Meanwhile, number one, I'm not a doctor. I'm not qualified to say that. But it's usually a bent up either racial, discriminatory, or just pure hatred of the other individual, right? In my view. And I think it's a very system-wide problem. I remember Steve Mantis, he used to work with the WSIB when they were working well with injured workers. Now it's a very problematic relationship, if you even want to call it. And he had mentioned to me back in 2010, early 2010, that they were working on a campaign, a stigma campaign, and they even had a poster. And it was really, really well put together to raise awareness about it. And then the new president came in, I think it was David Marshall, and he stopped everything. What's ironic is that the Supreme Court had said regarding chronic pain is despite this reality, since chronic pain sufferers are impaired by a condition that cannot be supported by objective findings. Richard, how many times do you see with the board and saying we require objective medical evidence? And when I look at the law, the one thing I learned about dealing with witnesses is there's two types of witnesses. A lay witness who is only allowed to testify about what they saw, they heard, and they observed, That's it. They cannot give their opinions because they are not an expert. An expert, once they've been said they're an expert, can give their opinions. Well, that's what a doctor is. Regardless if they're a psychiatrist, psychologist, or a family doctor, they're an expert in their field. To my understanding, family doctors spend many years in university and training to become to that level. And for the board to say, well, we don't believe the doctor, we require more. I literally was at an appeals hearing of the WSIB about 6 months ago, and the appeals officer said if they get a functional abilities form, which is properly filled out and says worker cannot return to work, they ignore it. In other words, if that's the only thing, they will deny the entitlement. And I'm like, you can't do that. Because then that's when the decision that I keep talking about as well is Fiera, where it literally says you cannot put your own opinions in place of medical evidence because you are becoming a doctor. And I think this stigma is part of it. It isn't and it is, right? I think it's two separate issues, and it's
Josh,
really,
when
go ahead, Richard.
if you've got a client with both chronic pain and psychiatric problems, say depression, which would you choose?
Okay, so that's an interesting question, and I was thinking about that, and we actually had somebody recently who I had to actually write submissions based on whether I thought they had CPD versus psychotraumatic, and I think based on the stacking of the nails, it's to your advantage to go for psych every single time, because then they could get their organic nail, and then they could get their psychotraumatic nail, and you can add them together, whereas CPD you can't. So I mean, I think that's a hole in their policy is that. Um, One is clearly advantageous. You can get a higher nail, you can get a higher permanent impairment. It can affect their restrictions, their ability to work. So I said, I went with psychotraumatic for that one, and I think it's to your advantage to do that every time.
What's the big split between the two? Like, where do you draw the line going one way or the other?
Okay, so I looked into that as well, and we can put these decisions up at some point. Um, there's a decision from WSIAT, which is 1791/07R2, and it says, determine whether a worker's injury would be best compensated as CPD because the character of the disability is most closely associated with pain, which cannot be attributed to organic causes, or whether it would be best compensated as psychotraumatic disability because the character of the disability is most closely associated with a psychological condition, e.g., depression. So, does that make sense to you, or?
So is it saying that if your biggest problem is you're depressed, you go the psych route? If your biggest problem is you got a lot of pain somewhere, we go the chronic pain route.
That seems to be what it is, but it is interesting that in that same paragraph, in that same decision, they say, it is not surprising that in many cases there will be overlap. However, given the holistic nature of the rating schedule, which applies to both CPD and psychotraumatic disability, compensation is not provided twice, in circumstances where a worker suffers from both a chronic pain disorder and a related psychological condition. So yeah, you have to pick one.
But
Take
when they
take the
say,
work. Yeah. Let me just
sorry,
ask
Richard.
you another question. Take the worker who say has a bad arm and is depressed. And the board says, well, your depression is very large, so we'll go on the depression route. In the meantime, can he also argue that in terms of return to work, I can't work doing anything with my arm, so I have to be accommodated both for my depression and all the pain in my arm, even though the board goes the depression route?
I mean, I would say yes, provided the injury is, quote unquote, serious enough to have actual restrictions other than pain. Because I know the board is always saying pain cannot be the only reason why a worker can't work. So, let's say the arm injury,
That, with
you,
all due
you can't.
respect, that defies Nova Scotia, which the Supreme Court clearly said pain on its own is entitlement for benefits.
And I've actually had cases where they did grant entitlement because of pain. I mean, like it's the whole thing is silly to me because it's they say, well, you have to not be able to move your arm, for example. So what if it's pain that's causing you to not be able to move your arm? Like what if you can't raise your arm over your shoulders because you're in too much pain? I mean, like what else is there other than if you have surgery and you can't actually move your arm physically? So yeah, to me it's weird.
I think the problem is that the board and its policies are treating pain as a psychological thing when it's actually, in my opinion, it's a physical. Because when nerve endings are damaged, that causes pain. It's an indicator. And I think they're manipulating the understanding of pain to say it's psychological and then denying them. I'd also like to ask you, when they say, in your interpretation, when they say compensation is not paid twice, what do they mean, compensation?
I think they mean nil awards. So I don't think they mean loss of earnings benefits. Obviously, we know that you can only get up to your, 85% of your pre-injury wages. I think they mean nil awards. And that's what I was saying earlier, that I think it's odd that you can stack your nels if you have an organic injury and a psychotraumatic injury, but you can't stack your nels if you have an organic injury and CPD. Um,
It, it
yeah.
goes to my argument in previous episodes about the view that when the Supreme Court in 97 in the Saskatchewan case said workers lost the right to sue employers and in return they got a right to workers' compensation benefits. But as you can see, and my first argument is when they impose forced return to work. So I go back, they say, okay, I'm injured today. And then Richard's my case manager. No, I'm just kidding. And he says, get back to work, you can work. But I'm in severe pain. I lack mobility, can't cut the grass, can't shovel the driveway, can't service my wife. You know what I'm saying, right? But seriously, those are limiting factors, which is warranting of something more than just saying it's only loss of earnings benefits. Because under the new model, since 1990, the legislature and the board and the whole workers' compensation system in Ontario has been fixated on just loss of earnings, and that's it. And they've done a pathetic job of saying your injury itself will pay you peanuts for. And my argument is okay, great, but if I have a short term injury where I don't get that NEL, where there's pain, like you're saying, or traumatic injury or whatever, because remember, there's two types there's long term, short term, right? No matter what the injury is, they're saying you don't get any entitlement, you don't get any compensation for it. So that then goes against what the Supreme Court's position is, right? In saying that there's a historic trade-off. And if there is no historic trade-off, then the right not to sue your employer is unconstitutional, right? That's just a point I've been trying to make for some time, hoping to kind of interest legal scholars in that because I'd love it for somebody to say, no, you're wrong, it's this. But nobody does because it defies common sense. And I think when you look at a system like the compensation system, where it is so out of whack, and Richard, how many times have you brought up compared to personal injury? where if you suffer a back injury or severe chronic pain, your quantum is like $300,000 or more. And there's other benefits too of that system where not only do you get a payment and you're secure and you're done, yes, you have a court battle. I concede that point to the courts. But when it's done, it's done. You don't constantly have a barrage of constant attacks of get back to work and constant suspicion. And recently, like in the R.V. Curtis case that went to the Court of Appeal, fear of being persecuted in provincial offenses court and facing jail time. I mean, I used to always support the compensation system in administrative law, but after so many years, there's been a complete twist on it. And every time I hear stories about, like yours, Josh, where you're bringing up these very interesting and valid points, I become even more concerned that either they're intentionally breaking the system, like our healthcare or public school system, to move it to private system, or I don't know what they're doing, you know?
Well, I mean, and there is that saying, never attribute to malice, so it can be attributed to stupidity or something like that. Um, I agree with you, and I've only been doing this for since 2020, but I've done the research on the way things used to be, and it used to be called the Workers' Compensation Board, and now it's called the Workplace Safety and Insurance Board, and it's like clear that it's not a compensation board necessarily. I mean, it is in name, kind of, or not in name, but it is in practice, kind of, but it's really an insurance, agency for the employers.
I think what's key is the one statement, and you always hear injured worker advocates mention the Meredith principles, the five principles. I don't do that. What I go after is the more important statement that Meredith said, which was the purpose of a fair and just compensation law, which is that when workers or workers are injured, it's to prevent them from becoming a burden to their family, friends, but most importantly, he says to society, I say to taxpayers. Because when an individual is injured and suffers an injury and they can't work, well, what happens? They end up falling onto the social programs, and who funds them? Taxpayers. And this is something that isn't thoroughly thought out. When WSIB is given back how many, 8, $10 billion, where's that money coming from and at what cost to taxpayers, you know?
I have another question for Josh, which is what type of medical treatment does the chronic pain sufferer receive versus the medical treatment that the depressed person receives? And what would be your views of each of those treatments in terms of its effectiveness and correctness?
Well, I mean, that's a good question. The one thing that I have noticed is that they'll give chronic pain sufferers stuff like spinal. They insert something in your spine to give you shock waves to deal with the pain. You get stuff
Nerve
like
blocks.
gabapentin. Yeah, you get nerve blocks. You get stuff like gabapentin, which is a nerve medication.
Gabapentin's very bad.
Yeah. So and then the psychotraumatic, you'll get antidepressants and you'll get talk therapy and whatnot. I think that you both get talk therapy, and I'm actually a big proponent of talk therapy. I think it is you're very helpful. I don't agree with giving people opiates and whatnot and just kind of feeding them drugs. So I would say there's overlap that they both get drugs, but the chronic pain sufferer unlike the psychotraumatic disability sufferer, we'll get stuff like spinal. I forget what it's called. I think it's radio frequency ablation. You get a little thing installed in your spine to give you shock waves and deal with the pain. So I think they are kind of, saying that it is an organic issue. It's based on something. Whereas I think what Paul was talking about with the stigma, they're saying, well, we can't see anything, so there's nothing wrong with you, and they're trying to, they give you drugs to just kind of sweep you under the rug.
Do we
I
have
think I think
any
that the
clients who've gotten improved their health through any of these treatments?
not that I know of, but I don't
Gimmicky
I don't know if the idea is to improve the health. I think it's just to improve them, enough so we can say, all right, we did our best.
ability.
You got to go back to work now.
Yeah.
That's But
I,
I
I've
can't think of any of our clients where where I've spoken to them and they said, you know what, that really worked for me. I'm better now, or I'm at least 10% better now.
And I've noticed too with the board, I was shocked to find out that like in the Nova Scotia case, which was 2004, the Supreme Court said, no, they're to receive benefits, they're done, right? Meaning they're unemployable. What I've noticed with the board is in Ontario is they've taken, as far as I'm concerned, a very dirty approach to it. They've done this a roundabout way. They said, okay, no, we're compensating you for chronic pain. We're going to give you an NEL. Great. But then they turn around and say, well, we think you can work. So they send you to this retraining program. And if you say, well, I'm in pain or it's difficult, well, you're not cooperating. It's all on you. And this becomes a bigger problem because if pain is the impediment, or in many cases I've read where it's not just pain, it's the pain medication. Like I know you talked about opiate pain medications. I agree with you. My philosophy on pain medication normally is that you take the pain medication, like any doctor would agree, is there's that hump of recovery, and it's to get over that hump so you can get into recovery. But then if it becomes chronic, then you've got another problem altogether. Um, what the problem is the board isn't recognizing these. I remember reading a tribunal decision, I can't remember the number, and I was in utter shock that they blamed the injured worker for the side effects of the medication, saying, well, you could have went to your doctor and got something else. And they're lucky I wasn't there because I would have said, really? Tell me a drug, any drug. Just name one that doesn't have any side effects. There isn't any, right? And that's what frustrates me. They're literally victim blaming. You have chronic pain, you're faking or you can work, but they're not looking at it. Chronic pain sufferers have waves in many ways where today they might be okay and they can do a few things. Tomorrow they're literally bedridden. Many injured workers I talk to get like that, and they could be like that for several days. No employer on this planet would go, okay, that's good, we'll hire you. None. And I think that was the old test for the WSIAT for unemployability, where they would say you must be able to be competitively employment to work 8 hours a day, because they're looking at the job market, because the board isn't going to be always there. Well, they're never there, but they're not there to support and prop you up. And I think that's something that's missing, not just at the board level, but now I've noticed a change in the tribunal where they're taking on this position of victim blaming. And I think it almost seems like it has to go back to the Supreme Court, and the Supreme Court has to say, look, stop going after these people that have severe chronic pain, right? Like, I really sympathize people that develop chronic pain because I'm like, oh, your future is gonna be very bleak. You know what I mean?
We have several clients. I've got cases ongoing where the WSIB says, yes, you have chronic pain, or yes, you have some depression, but you could still work 20 hours a week. And the worker's saying, I can barely work at all functionally. How do you come to 20 and what's the dividing line here?
I actually had a case, and it's funny you said 20 hours, and it was literally 20 hours. It wasn't the board, it was actually the vice chair. And the vice chair said, I think you can work 20 hours a week because you went to school for 20 hours. But here's the thing. In the documentation and the record, the worker worked 20 hours, but then couldn't anymore. Moreover, the injured worker's doctor said this person can never work again. They're done, right? And the vice chair completely ignored all that evidence. And I cited Fiera saying, you're not a doctor. You can't make these medical determinations. And this is something that case managers, appeals officers, and vice chairs are doing all the time. And I keep throwing at Fiera. And, it's funny, Richard, because initially I was very successful using that. But now it just seems like the tribunal's just kind of going, yeah, we don't seem to really care anymore. Where they're just going with this denying, and it's kind of disturbing. In that case, it was denied simply because of time. And I was like, really? It was 6 years. My own reconsideration that I had in my third reconsideration was 17 years from the original decision, and it was granted. So it's not, time isn't a factor. So it's the tribunal's supposed to look at the justice of the case, meaning in the interest of justice, in fairness. And it's that feeling, I keep going back again to that recent survey done by the Law Societies of Canada on Canada's legal system. And there's a website called Hours to Protect, and they reference the study. And the numbers actually shocked me on Canadians' view of our legal system, where they were very concerned about its lack of impartiality, access to justice, and disturbingly long delays, you know?
When we meet someone, potential client who has psychological issues, what is it we need from them for us to do the case?
So, we need them to see a psychiatrist or psychologist, and we need to get a diagnosis, and we need to get the psychologist or psychiatrist to comment on whether the work injury led to or caused or significantly contributed. And I think, to touch on a little bit of what Paul was saying is that um, they are the tribunal I think is pretty good. I think the WSIB is pretty bad, and they'll find any excuse they can to deny. So if we don't have a report that's recent, if we have a report that says maybe this person has other issues that are contributing, if there's one single doctor that says they can work full time, then it's not going to be good enough. So we need that psychologist to lay it out and explain in great detail how this work injury led to the psychological. And as we know, there's three different criteria, right? The head injury, the traumatic event, and the being off for a long time, basically. So we need to have them explain how the worker meets one of those. Usually, it's uh, they've been off work for such a long time. They've lost their independence. They've lost their ability to deal with family, and that's caused them to have psychological issues. A lot of it is loss of identity. You're a worker, and then all of a sudden you can't do what you used to be able to do.
I was running into some case law where it says if you suffer psychological disability or extra disability psychologically while you're in a return to work plan, such as a work placement, you can't claim that. Does that make any sense to you? Am I right?
You're right, but you're
In the
also right.
law.
Well, it's the way they've applied it. They've said, I think, what they often try to say is decisions of the employer cannot be the reason why you developed psychological issues. And I think what they're doing is they're saying, well, decisions of the WSIB are also not a reason why you got psychological disability. And I fully, strongly disagree with that. I mean, to me, if you have a bad experience in a return to work plan, like you would not have even been in that return to work plan unless you had the work injury. So to me, it's all connected, and it's another thing that they use to deny people. And I disagree
What's
with
the
it.
appeals tribunal saying about symptoms that get worse while going through the WSIB decision making and B, the return to work plan?
I mean, there here and there you can find a case or a decision that says, we're going to take it into consideration, but oftentimes they'll deny it. Still the tribunal will do that, but they are better than um, the WSIB. Although I think that the entire thing needs to be kind of reformatted because that half of our clients say, well, the return to work plan was unfair and they that my return to work specialist was not treating me well and whatnot. And I think that's perfectly valid.
How much does it cost to get one of these psychological reports to support the case?
I mean, generally, if the person already has a psychologist, they'll charge somewhere between 1,000 and 2,000. If they don't, they have to find someone. We have people that we use that are 3 to 4,000. So it's not cheap, and I think that's another issue with access to justice. However, I will say that if we win the case, then they can get the money back that they paid for the report
How?
If they win.
if they win.
How,
So
how do they get it
we
back?
you have to send in a request to the WSIB and send them the decision and say, Dr. So and so was used in this decision. Can you please reimburse us for the cost? And you got to send the receipt and you got to send the invoice. But there is, of course, there are rules to that as well. If you wait a couple years, you know, even if it's not your fault and there's a delay, then they'll reduce the amount you can get back.
Yeah. The one point,
Paul, I'll give you the last word.
yeah, just very quickly on return to work. I'm in agreement with you, Josh, because, and I always give this worst case scenario. I don't know of it happening. It's just the worst case scenario. And that is you're a worker, you work in a convenience store, and either you're a woman and you're attacked and raped, or you're a guy and you're physically attacked. You now suffer from physical and traumatic injuries. The WSIB return to work specialist comes along and says, okay, you got to go back to work. You got to go back to that workplace, and your employer says it. You then have a mental breakdown. According to the law and the board's policies, that breakdown, that situation is not compensated for by the board, which in that situation, I would definitely file a charter challenge, and any rep should, in saying that that section of the law is unconstitutional, as they did with PTSD before, if you recall. That's where the reps were challenging the law. The only thing that I had issue with the reps doing that is that they were doing it, yes, at the WSIAT, but I wanted them to wait and go to the court, because if they had gone to the court, it would have wiped it out for all injured workers with PTSD with no time limit. Well, I mean, the court would have probably imposed, but what they did was is then the legislature swooped in and said, okay, as of this date. So one day before, if you had PTSD, you were out of luck. Which I'm like, how does the legislature justify that? And they don't.
All right. Well, thanks, Josh. Thanks, Paul.
Thank you, Josh.
And see you all next week. Take care.